but it still exists.
The standard there would be indisputably clear.
It's a very high standard, but it would take care of the clearest errors. Now, there's a question, and so even if, which I don't think it's clear, but even if there weren't original habeas in this court, which is what I think the hook that petitioner relies on, there's other avenues for this court to address these issues.
Mr. Yang, when you and Justice Kavanaugh were talking about the clear statement rule, your answer to him seemed to reduce to habeas is different. But, of course, Castro is a habeas case, and Castro dealt with the very habeas provision that we're talking about here. And I guess you referred me to earlier sentences from Castro, and I've read those sentences again now. Mm-hmm. And I really don't see how it gets around what Castro says, which is that you need a clear indication to when the interpretation would limit our jurisdiction.
I think it has to. This is a two-step process. First, the court recognized we already allowed this for the government. Now we're talking about the flip side. Same question, though, about whether it's second or successive, whether that's barred. And then you look at Utah versus Evans, which is ultimately the site for the narrow reading.
Yeah, but
provision.
Utah, I mean, that's the kind of site that people throw in because it has good language. So I don't think you can read Utah v. Evans back into this.
Well, there's two things actually going on in Utah versus Evans. First, which I don't think applies, but it says that with respect to this narrow reading, it rejects the argument that because Congress allowed a pre-census challenge, it precludes a post-census challenge. But that's about any review. It's not this court's review.
This is not an opinion, is what I'm trying to say, where it says, really we should look to Utah v. Evans for the rule, and describes why or describes how this case is the same as Utah v. Evans. It's just plucking some language from Utah v. Evans. But the purport of this paragraph is quite clear, is that because there's a construction that limits our jurisdiction, you need a clear indication.
But the part of Utah versus Evans, which is actually analogous to what's going on here, is there the court said that it was not going to read into a statute an unexpressed intent to bar jurisdiction that we have previously exercised. And there the court had previously exercised post-census review. And here what the court is saying is we've previously exercised jurisdiction when the government comes up saying this is second or successive when it was deemed not to be. And here's the flip side. Here is the prisoner. Now, maybe on that
I don't read any of that in this paragraph.
Well, this is how we read the paragraph, because there's three sentences in the paragraph.
The paragraph doesn't say any of that.
Well, it's true that the paragraph doesn't say that explicitly, but I think you have to read between the lines. Anyway, the principle that this court's cert jurisdiction is always...
I would be reading between the lines so that we could do your policy arguments.
Well, no, I don't think it's a policy argument. We have textual arguments. But I don't think... This is also actually a relatively significant question that intersects with Congress's authority to exercise its exceptions clause. And I think there, the question is, why do you need a clear statement? This has not been followed by this court. This is kind of an isolated thing. And if you look at the authority for it, it just doesn't bear fruit, particularly when you look at how the court has construed its mandatory jurisdiction.
Well, Mr. Yang, there's been a lot of talk